Welcome to my comprehensive training on the California Residential Purchase Agreement Package. This session is designed to equip you with a thorough understanding of the 2024-2025 CAR forms, ensuring you can confidently navigate real estate transactions. My goal is to provide you with the essential knowledge and practical insights needed to guide your clients through every step of the purchase process, enhancing your professional capabilities. As a quick reminder, this video has a written presentation to follow along. Don't forget to download a copy from my training website so you can print it, follow along, study it, and make notes. The link to the training website to download this presentation is on the screen and in the video description. And if you enjoyed this training, be sure to subscribe, like, and comment. Let's begin by outlining the core documents involved in a real estate transaction. We'll cover the agency disclosure, the foundational California Residential Purchase Agreement, and various critical supporting addenda and advisories. Understanding how these forms interrelate is crucial for a smooth and compliant transaction process, ensuring all parties are properly informed and protected. Our initial step in any transaction is to clarify the agency relationship. It's vital that clients understand the different types of representation available from the outset, allowing them to make informed decisions about their engagement with you. Remember, commissions are always negotiable and not set by law. A key point to transparently communicate to your clients. There are three primary types of agency relationships you'll encounter: seller's agent, buyer's agent, and dual agent. A seller's agent works exclusively for the seller, owing fiduciary duties to them. A buyer's agent acts solely for the buyer with their consent. A dual agent represents both parties, but only with full knowledge and consent from both sides. Regardless of who you represent, all agents share fundamental duties to both the buyer and seller. These include exercising reasonable skill and care, ensuring honest and fair dealing, and disclosing all known material facts that affect property value or desirability. However, confidential information from the other party remains protected and should not be disclosed without explicit permission. In a dual agency scenario, there are strict limitations on what an agent can disclose, such as one party's willingness to adjust their offer price or financial motivations. It's imperative that parties understand agency duties don't absolve them from protecting their own interests. Always advise clients to seek professional legal or tax counsel, especially regarding complex financial implications, as these fall outside an agent's scope. To ensure clarity, the Civil Code provides specific definitions for key terms in agency relationships. An agent is a licensed broker facilitating a transaction. A buyer or seller refers to the transferee or transferor of property. A dual agent is an agent representing both parties. A listing agreement is the contract authorizing an agent to sell property. The Civil Code outlines specific disclosure and confirmation requirements. Sellers and buyers' agents must provide disclosure forms as required. If a party refuses to sign an acknowledgement, appropriate procedures must be followed. Furthermore, agents must clearly confirm whether they are acting as a single agent or a dual agent for the transaction. Beyond basic disclosures, the Civil Code addresses additional provisions. Compensation does not dictate an agency relationship. Commissions may be shared. A dual agent must maintain confidentiality. Agency relationships can be modified with written consent. Importantly, these provisions do not diminish any existing duties of disclosure owed by agents. The California Residential Purchase Agreement is the bedrock of nearly every home sale transaction. It's a comprehensive document that outlines the terms, conditions, and responsibilities of all parties involved. Mastering this agreement is fundamental to your role as a real estate agent, ensuring smooth and legally compliant transactions for your clients. The agency confirmation section formally declares the roles of all participating brokerages and agents in the transaction. This includes identifying the seller's brokerage firm and agent, and specifying whether each acts as a single agent or a dual agent. For buyers, these details are completed upon their representation. This ensures transparency and consent for the agency relationships. Paragraph 3 of the RPA details key financial items. This includes the specified purchase price and the close of escrow date, emphasizing that time is of the essence. It also defines the initial deposit, typically delivered within 3 business days, and outlines the loan amount, specifying the type and terms, with loan verification due within 17 days. This section addresses important elements like seller credits, standard contingencies, possession terms, and offer expiration. Understanding these provisions is vital for managing client expectations and ensuring all financial adjustments, conditional clauses, property access, and the overall timeline of the offer are clearly established and communicated. This section focuses on the specifics of the deposit, financing, and loan terms. It outlines the delivery process for the initial deposit and specifies requirements for all cash offers, where no loan contingency applies. It also details the necessity of loan verification letters and clarifies that the seller relies on the buyer's stated financing type. At the close of escrow, the property is delivered as is, maintained in its current physical condition, with all debris removed. Sellers provide keys and access for all systems. All assignable warranties are transferred to the buyer. Agents should advise buyers to thoroughly investigate, as defects may exist, and improvements might not be up to code or permitted. Contingencies are critical protections within the RPA. These include loan, appraisal, property investigation, insurance, and seller document contingencies. Each must be removed in writing within its specified time frame. If a buyer fails to act, the seller may issue a notice to buyer to perform before canceling the agreement. Loan and appraisal contingencies are crucial buyer protections. The loan contingency allows the buyer to cancel if they cannot secure financing. The appraisal contingency protects the buyer if the property doesn't appraise for the purchase price. Both are subject to specific timelines and the provisions of the Fair Appraisal Act. Paragraph 9 delineates items included and excluded from the sale. Typically, permanently attached fixtures, appliances, and certain security or smart home devices are included, while personal property is excluded. It's essential to specify all items in writing, as anything not listed is generally not part of the sale, and all included items transfer without seller warranty. Paragraphs 10 and 11 detail the allocation of costs and statutory disclosures. Payment for inspections is determined by specific clauses. Legally required installations like smoke alarms must be completed promptly. Home warranties are discussed, with buyers choosing and paying for their plan. Sellers must deliver numerous statutory disclosures within 7 days, which cannot be waived. Additional statutory notices inform parties of important public information. This includes Megan's Law for sex offender data, pipeline locations from the National Pipeline Mapping System, and mandated natural hazard disclosures. For HOAs, sellers must order documents like CC&Rs and meeting minutes within 3 days of acceptance for buyer review. Buyers have the right to conduct thorough investigations, inspections, and tests at their expense. Sellers must cooperate by making the property accessible and ensuring utilities are active, while invasive or destructive investigations require the seller's prior written consent. Buyers are encouraged to explore all aspects of the property's condition, from structure to environmental factors. This section covers the title and vesting of the property. A preliminary report, an offer for title insurance, is provided within 7 days. The property is sold subject to existing encumbrances, except agreed-upon monetary liens. Buyers receive an Alta homeowner's policy or equivalent. Advise clients to consult professionals on how to take title, as it has significant legal and tax consequences. Paragraph 14 outlines contingency removal and cancellation rights for both parties. Sellers can cancel if buyers fail to remove contingencies or deliver funds after notice. Buyers can cancel if sellers fail to meet obligations or deliver documents. A demand to close escrow must be issued at least 3 days before cancellation due to a failure to close. Paragraph 15 specifies that any agreed-upon repairs must be completed before final verification, comply with applicable law, and include permits. The seller must provide invoices and receipts. Paragraph 16 allows the buyer to conduct a final verification within 5 days of the close of escrow to confirm property condition. Paragraph 17 details prorations for property taxes, HOA fees, and other costs, typically based on a 30-day month. Paragraphs 18 and 19 define broker responsibilities, compensation, and escrow instructions. Broker compensation is based on separate agreements, with the buyer's broker a third-party beneficiary. Agents do not provide legal or tax advice, nor do they guarantee property conditions. The RPA constitutes joint escrow instructions, and compensation disclosures are provided by the escrow holder. Liquidated damages may apply if a buyer defaults, allowing the seller to retain the deposit under specific conditions. Mediation is often a required first step to resolve disputes before proceeding to arbitration or court. Arbitration provides a binding resolution through a neutral third party, offering an alternative to traditional litigation, provided both parties have consented to it. Offers have specific expiration times. Revocation is possible until acceptance. Entity buyers must be clearly identified. Sellers have options for accepting, rejecting, or counter-offering. The contact information for the seller's brokerage and agent is clearly listed, ensuring proper communication channels are established for the transaction. The Federal Reporting Requirement Purchase Addendum introduces new obligations under FinCEN rules, effective March 1, 2026. This requires reporting persons, usually escrow or title companies, to collect and report specific information about both buyers and sellers to the U.S. Treasury. This measure aims to prevent money laundering within real estate transactions. This addendum specifies the conditions under which a transaction must be reported to FinCEN, outlining the types of sales that trigger these obligations. It also details the exact information required from both buyers and sellers, ensuring compliance with federal mandates. All necessary FinCEN information must be delivered within 7 days. The Buyer's Investigation Advisory is a crucial document that informs buyers of their responsibility to thoroughly investigate all aspects of the property. It emphasizes that sellers and agents may not be aware of all defects and strongly encourages buyers to conduct their own due diligence to uncover potential issues before committing to the purchase. Buyers should investigate several key areas. This includes the general condition and systems of the property, such as structural integrity and mechanical components. Environmental hazards like asbestos or lead paint require attention. Understanding potential fire and other hazards, along with insurance availability, is critical. Lastly, a thorough investigation of the neighborhood and surrounding area is essential for informed decision-making. The possible representation of more than one buyer or seller advisory clarifies that a brokerage may represent multiple clients simultaneously. This means different agents within the same brokerage could represent competing buyers or multiple sellers. If dual agency occurs, consent is required, and the agent cannot disclose confidential information without permission. The Fair Housing and Discrimination Advisory reminds us of the federal and state laws prohibiting discrimination in housing. These laws ensure everyone has equal access to housing opportunities, regardless of protected characteristics. Agents must be well versed in these regulations to uphold ethical standards and avoid potential violations and associated penalties. The Homeowners Insurance Advisory warns buyers about the challenging insurance market in California, advising early exploration of options. The Wire Fraud Advisory highlights the significant risk of hackers intercepting wire transfers. Clients should always verify wiring instructions via a pre-established phone number, never solely relying on emailed instructions, and consider alternative payment methods. Before we end, and as a final reminder, this video has a written presentation to follow along. Don't forget to download a copy from my training website so you can print it, follow along, study it, and make notes. The link to the training website is on the screen and in the video description. And if you enjoyed this training, be sure to subscribe, like, and share. The California Consumer Privacy Act Advisory informs consumers of their rights regarding personal information collected by businesses, especially in real estate transactions. These rights include knowing what data is collected, correcting or deleting it, opting out of transfers, and limiting the use of sensitive information. Agents must understand this, as client information is shared with various entities during a transaction. Final disclaimer: none of this information should be considered legal or tax advice. I am not an attorney or CPA. Consult your own attorney, CPAs, and/or broker.